Namaste and welcome to day 6 recap of Chapter 12 sections with respect to directors' provisions in company law. And today we'll do the recap of sections. Yesterday we did sections 180 to 187. Yeah, so these were the sections we did yesterday, around 8 sections, and we'll quickly do the recap. So we saw in Chapter 12, we saw sections 173, meetings of board, 174, quorum, 175 is resolution by circulation, 176 was defects in appointment of directors, 177 was, now 177, 178 are together, audit committee and NRC and SRC, 179, 180 goes together. So 179 is powers of board of directors and 180 is restrictions on powers of board of directors. So that goes together. So we saw powers of board of directors, that is call, buyback securities, borrow, invest, loans, adato, PKR, read with the rule. So that's PKR. And then we have certain powers. So these powers are restricted, means certain powers should be exercised only through shareholders meetings by passing special resolution. Yeah, that also special resolution. And this section is not applicable to private companies. And so which are the powers which are to be exercised only in the shareholders meeting? They are SIBD, SIBD. And what is that? Sell, lease or dispose of whole or substantially whole of the undertaking of the company. And the undertaking is the one in which investments exceeds 20% of its net worth, or which generates 20% of the total income of the company. And substantially whole undertaking is 20% or more of the value of the undertaking. So that's SI, implies to invest otherwise in trust securities as a result of merger or amalgamation. SIB, borrowing in excess of paid up capital, free reserves and securities premiums. So borrowing in excess of PFS, and temporary loans which are less than 6 months are not counted in this. And D, SIB, SIB D. D is remit or give time for the repayment of any debt due from a director. So that's all about section 180 primarily, and we need to pass special resolution and all to seek shareholders approval. And then we have section 181, 182, 183, that is related to, again they are all together, and that's related to donations for different purposes. So we have section 181, that is 8, section 8 is a charitable company, a big fat lady. 8 implies a fat lady, so a big fat lady has a big heart, and so section 8 is a charitable company, and charitable company is supported by 2 pillars, so 181, and that's donations to charitable funds, and second one is donations to political funds, and third one is national defense funds. So in case of, as per the table, section 181, which discuss about donations for charitable purposes, so that donation, that contribution should not be more than 5% of the average net profits of past 3 years, and it can be any person, any company can give. Then we have section 182. 182 discusses about political contributions. So in this case, donations can be given to any amount, any extent. However, there are certain conditions to be fulfilled. Government company cannot give donations for political contribution, and no company in existence for less than 3 years in existence. So that is less than 3 years old company cannot give donations, contributions for political purpose. The board meeting should be in physical form. So board meeting should be held, and this item should be taken in the board meeting. And most important is, in case you do not fulfill these conditions, then the jail and penalty is levied to the extent of 5 times. So that's all about section 182. And 183 is national defense funds, that is contribution of any amount to national defense funds can be done. And further we have, so that's about section 183. And then, so we have done 181, 182, 183, 3 contributions, donations. Then we have section 184, disclosures of interest by directors. And this disclosure of interest is disclosed in MBP1. MBP1 form, we have to disclose the interest, and most important, this disclosure is to be made in the very first board meeting in which the director participates, and thereafter in the first board meeting in every financial year. So every first board meeting after 31st March, the director is supposed to give MBP1 to the company. That's how it is done. Further, every director, whether directly or indirectly, they are concerned or interested in a contract entered with a body corporate in which he holds 2% or more of the shareholding. So if he's holding more than 2% shareholding, or is a promoter, manager, CEO of that body corporate, or if that director is related in such a way that with a firm in which such director is a partner, owner or member, shall disclose the nature of his concern or interest and shall not participate in such meeting. So when directors are interested in any company or firms, and with respect to the transactions held by the company along with the firm, they will not participate. However, if he becomes interested afterwards, after the contract or arrangement is entered into, he will disclose his interest immediately or at the very first board meeting held after he becomes so interested. And 184 subsection 2 shall apply to private companies with an exception. And what is the exception? That the interested director may participate in such meeting after disclosure of his interest. So in case of private companies, normally as per subsection 2, interested directors will not participate. They have to keep quiet. Kab chup baithne ka board meeting mein. But in case of private companies, they can disclose it and they can participate in the discussion also. And so that's the main crux of section 184. And subsection 2 shall apply to section 8 companies only if transaction with reference to related party transactions, that is section 188, on the basis of terms and conditions of the contract or arrangement exceeds 1 lakh rupees. Only in that case. So that's all about section 184, that is disclosures of interest. And then let's take up section 185, loans to directors. So can company give loans to directors? Yes, they can give. However, no company shall directly or indirectly grant any LGS, that is loans, guarantees or securities, to any director when any director of a company or a company which is its holding company or a partner or relative of such director, and any firm in which such director or relative is a partner. So they cannot give any loan to a firm also in which director is interested or his relative itself is a partner. And a company may advance any loan, including any loan represented by book debt or guarantees or securities in connection with any loan taken by any person in whom any of the director is interested, subject to following conditions. So in case of any loans, guarantees, securities are provided and directors are interested, you have to follow these conditions. What are the conditions? Special resolution, take shareholders' approval. First of all, provided that the explanatory statement to the notice of that particular meeting discloses all particulars of the LGS which is being provided, and that the purpose for which the loan LGS is proposed to be utilized by the recipient of the loan, guarantee or security. So how much amount you are going to give and what is the utilization of that loan amount will also be disclosed in the explanatory statement. And the loans are utilized by the borrowing company for its principal business. So in case it's a borrowing company, so holding company is giving to subsidiary company sort of, or any company is there, primarily any company is borrowing money, in that case they have to disclose it, they have to utilize it only for their principal business. And any person in whom any of the director of the company is interested means a private company in which such director is a director or member, any body corporate at a general meeting in which not less than 25% of the total voting power may be exercised or controlled by any director or two or more directors. So one or more directors are holding more than 25%, and nothing contained in 1 and 2 apply to giving of loans to MD or whole-time directors as a part of conditions of services extended by company to all its employees. So if other employees are getting loans and all that from the company, even it extends to MD also, and pursuant to any scheme approved by the members or by a special resolution. So that's what are the requirements of this particular section. And a company which in the ordinary course of its business provides loan or gives guarantee or securities for due repayment of any loan, and in respect of such loans an interest is charged at a rate not less than the rate prevailing yield of 1 year, 3 years, 5 years or 10 years government security closest to the tenure of the loan. Simple, it should be at normal rate of interest. You need to have arm's length transaction, in simple words. And further, any loan made by a holding company to its wholly owned subsidiary or guarantee or security provided by a holding company in respect of any loan made to its wholly owned subsidiary. So LGS by holding company to subsidiary is totally exempted. And further, we have provided that the loans made in C and D are utilized by the company. So whenever a company is taking loan, definitely they have to utilize it for principal business activities. So that's all important criteria, important element of section 185, that is loans to directors. And then we have section 186, loans and investments by company. Loans and investments by company is that companies can give LGS, loans, guarantee security, or they can make investments in companies. However, the investments in companies should not be more than 2 layers of investments. So there should be only 2 layers. So holding company, subsidiary 1 layer, subsidiary 2 second layer. After that, no more layers are accepted. However, in case of acquiring company incorporated outside India, and if such company has invested in subsidiary companies beyond 2 layers, then it's accepted. And for having any investment subsidiary for purpose of meeting the requirements under any law or under any rules or regulations frame. Plus, if you are acquiring by purchase or otherwise securities exceeding, it should not be more than 60% of PFS, that is paid up capital, free reserves and securities premium, or 100% of free reserves and securities premium, that is 100% of FS, whichever is more. And then we saw the illustration also, that how we have to calculate. So whatever we are giving LGS and investments, whatever we are making, you have to consider the aggregate amount, that it should not be exceeding 100% of PFS or 60% of PFS or 100% of FS, whichever is more. That is what we have to be very careful about. And where the aggregate of loans or investments so far already made, and if you are proposed to be given some additional loans or investments are proposed to be given, and it is going to exceed the limits prescribed, in that case, first take previous permission of the shareholders by special resolution, and then only do any additional LGS or investments beyond the limits prescribed. Okay, first you take the permission by shareholders, and further, all these investments and all that, you need to maintain registers, and these registers will be in MBP 2 and MBP 3, 4. I'll discuss that also accordingly. Further, so MBP 2 will be the format, the register for company will maintain LGS and all acquisitions that they made, investments they made in register in form MBP 2, and enter particulars of LGS and acquisitions in chronological order within 7 days. So date wise they will be maintained within 7 days. And so that's all about the recap of section 186. And 187 is investments of the company to be held in its own name. So companies must hold investment in its own name. However, they may hold investments in others' name, nominees and all that in certain cases. So all investments in any property, security or assets must be held in its own name. However, company may hold shares in its subsidiary through nominee to ensure that the number of members is not reduced below statutory limit. That's one thing. And nothing should prevent a company from depositing with a bank any shares or securities. Further, from depositing with or transferring or holding in the name of SBI or scheduled bank to facilitate the transfers. From depositing with or transferring to any person by way of security for the repayment of any loan, and from holding investments in name of depository. So all these exceptions are there. It will not be prevented. In all other cases, definitely the shares, securities are to be held in the name of the company. And that's all we have done with the recap of day 6 with section 187. So we have done recap of 180 to 187 sections.